Good afternoon again. Thank you so much for joining us for today's webinar to commemorate ESIGN Day 2022. My name is Jim Thompson, Executive Director for ESRA, and I will be your moderator. Our speakers today are Jerry Buckley and Kim Moyle. They were involved in advocating for the original ESIGN bill in 2000 and championed for the recognition of National ESIGN Day on the 10th anniversary on June 30th, 2010. Jerry is a founding partner of Buckley LLP, and who is in his 40-plus career year has established himself as an acknowledged leader in financial services law. And Kim Moyle is the managing director of K6 Partners. He is a licensed attorney and a subject matter expert in all facets of digital transformation. So without further ado, please welcome Jerry and Kim.
Well, thank you, Jim. And you know, this day is designated by Congress to commemorate the passage of the ESIGN Act that was enacted 22 years ago. For those of us who were present at the creation, the day brings back memories, but it also inspires us to consider what has already been enabled by ESIGN and the promise this statute holds to bring even more advancements in the future. ESIGN is a compact statute that affirms that electronic signatures and records will have the same force and validity as their pay-for equivalents, so long as the parties agree. But while the statute is concise, its implications and potential are immense. ESIGN had its origins in the effort of what is now called the Uniform Law Commission, then known as NICUSL, to create a uniform state law like the UCC. This uniform law effort involves some very talented and thoughtful regulators, lawyers, academics, and business persons. And the products of those efforts was the Uniform Electronic Transactions Act, or UETA. The concept embodied in UETA provided the groundwork for the federal ESIGN legislation. So if there was this idea of UETA out there, why did we need an ESIGN Act? And the answer is that while the expectation was that we would have uniform adoption, the first state to take up the Uniform Act, California, immediately excised all consumer transactions from the act. And that made clear that this wasn't going to be a uniform act, and we were going to have something happen at the federal level. And it made sense to have something happen at the federal level because it takes time for uniform laws to be adopted, and the electronic commerce was moving along quickly. And also the internet is a borderless medium. So having one standard without any state variations like were emerging in California made an awful lot of sense. Now, surprisingly, the ESIGN Act was actually a fairly heavy lift, because even though it sounds like it's a marvelous facilitation of electronic commerce, consumer advocates were concerned about potential abuse of consumers, particularly related to the provision of legally mandated disclosures in the financial services space. And they persuaded the Clinton administration in election year 2000, with Al Gore running for president, to oppose the legislation. When the legislation came up in the House, it faced a veto threat from the Clinton administration. I remember I had a meeting with Secretary of the Treasury, Larry Summers, now very famous for predicting inflation, but then Secretary of the Treasury. And he said to us, we are going to recommend that this not pass, because the consumer advocates, of course, had a large voice in the Democratic Party during that campaign. They did recommend that it not pass, but interestingly, the New Democrats, led by Jay Inslee, governor of Washington State now, and a congressman from Seattle, the New Democrats worked with us to come up with a compromise solution that addressed most of the consumer concerns and allowed the act to pass the House and ultimately pass the Senate and be presented to the president for signature. But to overcome those objections, the provisions of Section 101C of the Act incorporated in the statute specific processes to prevent consumer abuse, including a process of reasonable demonstration that the consumer could had access to a computer and was able to to receive the disclosures and exercise their rights. However, some aspects of this 101C provision are viewed as unnecessary hurdles in today's world to the end, and as a result, there are efforts pending to amend ESIGN to address these perceived hurdles. And Ken Moyle, my colleague on this presentation, will be addressing those later, and we may have a little conversation about that. The ESIGN Act is an overlay statute that impacts signatures and records in many legal and legislative contexts over a wide range of uses, not only financial services. But while it provides legal authorization, the Act isn't prescriptive as to how to authenticate the counterparty, for instance, what the signature process should look like, and so forth. As a result, about a year after the Act was enacted, some colleagues and I organized a committee to create standards and procedures for electronic records and signatures. This cross-industry effort over about a year and a half produced a guide of principles to follow in implementing electronic signatures and records. I served as counsel to the SPURS drafting committee, and my good friends David Whitaker and Margot Tank acted as recorders, creating what SPURS has become, a behavioral guide adopted now by the mortgage industry, the auto finance industry, and other aspects of the financial services industry, including the insurance industry. SPURS manual is available for those who might want it at the website spurs.org. Recently, ESRA, which is the sponsor of this session, has developed another resource, which will be called ESRA Standard 1, providing more information regarding electronic signature and record processes requirements. And I understand that will be released quite shortly. Another resource I'd mention is a book that was co-authored by Margot David and myself called The Law of Electronic Signatures and Records, which is published by Thomson Reuters. Well, enough about looking back. Let's turn to the transformative role that ESIGN has played and can play as we move forward. It is hard to imagine how we would have gotten through this time of COVID without ESIGN. After years of slow but steady adoption, slower than we had thought, and painfully slow for those of us who had invested a lot of time and effort in it, but slow but steady adoption, the processes that ESIGN enables were motivated by COVID, much more widely considered and adopted both by business and government. An example of this is remote notarization, which ESRA played a large role in promoting at the state level and getting state secretaries of state and state legislatures to recognize the importance of electronic signatures and records and the permission to do notarization electronically. And that is just one example of the kind of efforts made by ESRA. ESRA is the voice of the ESIGN community. It has grown from an idea that originated with a few players in my law office, a couple of my colleagues, Margot and David, in a conference room here, to become the recognized leader in ESIGN advocacy. Ahead of us lie many challenges and opportunities. What role will the blockchain play in this process? How will AI provide new tools for data management? How will rapidly changing privacy rules impact the collection and protection of electronic data needed to affect transactions electronically? How do we deal with data breach risks as cryptography evolves and the ability to break cryptographic codes evolves? For a process that relies, this is a larger question, but for a process that relies on the viability of the electric grid, what recovery plans are there if the grid is successfully shut down for some period of time? I'm sure Ken could add to this list, bringing his very valuable insights as an innovator and a person who knows how to look around the corner and anticipate where e-signatures and e-records are headed. So I'm going to turn it over to Ken now.
Thanks, Jerry. That was a great overview, both the history and kind of the roadmap for where this is taking us. And it would be, I think it would be a really important thing to say right now that even though it took a sort of a global pandemic to move things to the state where they are in terms of adoption of electronic signatures and records, and particularly remote notary, Ezra worked for years prior to this to lay the groundwork, starting of course with the ESIGN Act and SPURS, but also sort of a lot of tactical blocking and tackling, working with industry standard organizations like the Mortgage Industry Standards Organization, including and also government agencies such as the IRS, Fannie Mae, FDA, and others, to really build gradual acceptance and understanding of how electronic signatures and records work, what they are and they are not, and that continues obviously to this day. You had mentioned blockchain, for example. Ezra was, I think, very, very influential in the basically lack or removing the distortions and misunderstandings about what blockchain was and wasn't. There were a lot of attempts to amend e-signature electronic record statutes in light of blockchain transactions, because they used words that were unfortunately very similar to legal words, like, for example, smart contracts. It took a lot of work to explain to legislators and policymakers the difference between a legal contract and a smart contract. That's just one example.
And if I may interrupt, Ken, we owe a large debt of gratitude to you for leading the public policy efforts at Ezra during those years. Well,
thank you. It was a mission of love and necessity, I think. Like I said, there's a lot of meetings took place from the lowest levels to the highest, and a lot of thinking had to go through, I think, in terms of the entire collective group of Ezra, which, by the way, is made up of a lot of competing companies who understood the value of a one industry voice. And I think that was a major contributor. Without the ESIGN Act's really artful form of being an overlay statute, and as you've said many times, there is no regulator for ESIGN. There is no requirement to accept electronic signatures and records. This is a voluntary opt-in statute with a few hurdles, as you mentioned, for regulated industries who have required disclosures out to consumers that they have to go through. And so, without the kind of the help of an industry organization like Ezra, the uptake could have been a lot slower than it has been, and there's still a lot more to go. Of course, and again, I think having the pandemic, I don't want to say helped, but it made clear that there were alternative ways other than paper and ink to get things done and conduct business, both nationally and internationally.
Would you share, Ken, and I'll join in with you, what has happened recently regarding the hurdles that are perceived in Section 101C?
Yeah, absolutely. And this is really interesting because, Ezra for 15 years was very defensive of changes to ESIGN. I mentioned one objective of some folks who wanted to change ESIGN to mention and make certain rules for blockchain transactions. Well, it really wasn't necessary. The way that ESIGN was written, again, was sort of future-proof, and we were always beating that drum. But as the adoption of electronic signatures and records became more widespread, it became pretty clear that some of the changes to the original draft of the ESIGN Act, in particular 101C, as you mentioned, Jerry, requiring a reasonable demonstration of your capability to use a PDF, to have a computer. Those things seem sort of stale. They got kind of dated, and there was an outcry not only from regulated industries such as banks and financial services companies, but also from consumers saying, "Why is this so hard?" And so the ESIGN Modernization Act was put forward back in 2020, and Ezra helped take one of the early drafts of that and help not only fiddle a little bit with the wording, but also to help educate and explain as an expert organization to lawmakers why this made sense and how we could preserve and surgically change ESIGN without ruining the overlay statute and the beauty of the statute, but be able to kind of remove some of the barriers to adoption. One of the problems that, and I'm gonna let you jump in here, Jerry, but one of the problems that the banks and other financial institutions had was, how do you get reasonable demonstration of the ability to use electronic signatures and records at the point of sale in the bank when you want to have someone accept to do business electronically? Yes, I want to do business electronically. Well, you have to go, you can't do it here because you can't prove that you can use a PDF and have a computer. You have to go home and do it. So those kind of things were I think important to address at this day and age. And so that particular bill is actually, unfortunately, not, I think it's gone through committee, but it's not moving at this point because not a whole lot in Washington is moving right now.
You're absolutely right. I think it's fair to say, Ken, that the drafters of the ESIGN Act were wise drafters, and they drafted a statute that has proven to be very durable. But as I mentioned, those provisions that were inserted in order to address the concerns that some consumer advocates were raising have become hurdles, not insurmountable hurdles, but hurdles, and perhaps unnecessary hurdles in a world where practically everyone is doing business electronically and communicating electronically all the time. There was a great concern back in 22 years ago about the digital divide, and this is only going to be beneficial to those who could afford computers. Well, admittedly, computers are not available free, but they are available very, very widely and used widely. So,
not to mention phones, right?
Right, exactly. I mean, practically everybody has a computer in their pocket. So I think it is fair to say that that some of the concerns of that era are outdated, but it is, as you say, very hard. I spoke, the senator that has taken the lead on this is the actually high-ranking member of the Commerce Committee, which is the committee that had primary jurisdiction. And he is also the assistant minority leader in the Senate, a Republican. And, some Democrats are inclined to go along with this, but the consumer advocates are still there and still saying we need these protections. So it's been hard to move the legislation, and given that there are a few other things going on in Washington these days, I spoke yesterday with the staffer for the senator, and they said that it's probably not going to happen this year. Now, if the Senate were to change hands, and that's up in the air, maybe there would be something enacted, and then of course you'd have to deal with the Biden administration, which I think would be more progressive than the Clinton administration, but we'd have to see how the consumer advocates react there. Something should be able to be worked out on this, but there are many things here in Washington where something should be able to be worked out, but isn't.
Yeah, that's true. You know, we should probably mention, Gary, there's also efforts, and I think you touched on this in your early remarks, that over the past few years, another barrier to adoption is, again, the enabling legislation that doesn't have any prescription. And Spurs did a great job of basically, giving industries some grounding and some guardrails and some considerations to take. But there's always been, folks out there in the regulated industry saying, okay, but tell me how to do it. Tell me what I need to do. Don't tell me what I need to think, don't suggest to me what I should do. Tell me what I have to do. And I think it's really hard to do that without kind of taking away from the beauty of the overlay statute. But a standard has been developed and has been in the works by Ezra for some time now, actually some years now, and attempting to really tiptoe between that, that wide open capability, that the great American, ingenuity type of approach versus, please tell me what I need to do. And Ezra, because it's an organization that has a lot of respect among many industries in terms of its expertise, it's come up with a set of standards that takes the Spurs concept and takes it one step further in terms of coming up with suggested uses for security, for how to best present documents, for audit trails, authentication, things like that. And some of these basically say you really need to do this in order to meet our standard. Not to say that the standard is the be all and end all. It's a standard. It's one that's been vetted by many industry experts, and it's a kind of like a nice backstop for someone who's trying to make a decision about whether they have an adequate e-signature and e-records system that they're working with. So we're very excited about that.
And I think, Ken, just to go back to why these efforts like Spurs and Ezra Standard 1 have been necessary. The judgment was made, and I think it was the right one.
Yes. That
they did not want to have anyone appointed as a regulator to, usually when you pass a statute in Washington, you would designate a regulator and they implement it by regulations. It was thought that regulations would be cumbersome and hard to put in place. And if you could accomplish in the statute what the essence of what had to be done, it was better to do that than have a regulator in place. And the other problem was that regulations are very hard to change. And in a fast-moving technology environment, getting tangled up in a regulatory process was judged not to be the right way to go. And I think that the drafters were right in that regard. But of course, in industries like the ones that I serve in financial services, people are always looking to their regulator and saying, well, are they going to say this is okay when the examiners come in? Are they going to criticize me? I need something more. And the regulators are not authorized to issue regulations, but they have given some guidance. But these accepted industry standards are something that regulators can look to as well. So we're doing our best to try to move these things forward. Meanwhile, things are moving forward, and I think that's our basic message here today, that ESIGN has really facilitated dramatic change in the way in which we all do business. And,
well, to your point, Jerry, imagine if we had a regulator signed and they adopted their own standards at a federal level for what an electronic signature is and is not. We would still have only the technology that was available in the year 2000
exactly.
as our standard. And going back to the history of Uniform Electronic Transactions Act, that was a response to one particular state doing just that and saying, this is the only way you can have an electronic signature. And what was it? It was a digital signature using one particular vendor who I don't believe even exists anymore. That standard was actually adopted by Europe and put them 2 decades behind in terms of adoption of electronic contracts and signatures.
For those who are not inside Washington types, that's known as regulatory capture.
Yes.
If you're a business and you're able to get to the right legislators and get them to designate your technology as the one to be used, you've got a leg up, even though it's not necessarily a fair leg up. And I think that this statute has worked very well, and the drafters are to be congratulated for what they accomplished 22 years ago. Many of them are no longer in Congress. In fact, I doubt that any are really in Congress anymore, or in the Senate or House. But they did a great thing in putting this in place, and we owe them a great deal debt of gratitude. And to still active Governor Inslee, thank you for your role in bringing about the compromise that made this happen.
Fantastic. Yeah. Let's see. Did we hit everything? We got like a couple of minutes left. We hit. I think we talked about the Secure Act, right? With did we talk about the Secure Act with the e-notary?
We mentioned it, but we didn't go through any depth. I don't know whether with 1 minute left, it's fair to the Secure Act. Maybe we should give a minute back to our audience. So thank you so much. And Jim?
Great. Well, Ken and Jerry, thank you so much again for your time today as leaders in our industry, and obviously very instrumental in your involvement with Ezra, obviously, and of course with e-signature. We do thank you guys both for your support, and for everybody on the audience today. Again, we hope you found today's webinar valuable and useful. And again, on behalf of Ezra and our speakers, thank you for joining us today. Look forward to seeing everybody soon. Thanks so much, and have a great afternoon.
Thanks, Jim.
Thanks, Jim.